That introduction, I think we're done. It doesn't get better than that. So thanks, Julie.
Thanks again, everyone.
Thanks to Julie and Kimberly and to Tim for everyone at the IMA for helping us put this on and coordinate this. And thanks to all of you for being here. Just briefly I'll introduce myself, and Chris Parker will introduce himself. Again, I'm Dan Kaufman. I've been with Michael Best for over 22 years. It's hard to believe. I've been practicing for more than 25 years, and I practice in the area of employment law, which is handling day-to-day questions for employers, all sorts of employers, many manufacturers, but we've got Adam in the banking world. We do a lot of work with banks as well. And it's day-to-day questions, counseling, but it's also handling lawsuits when they arise, both from an employment standpoint and general litigation. And many of the situations I have handled relate to what we're going to be talking about today in terms of ways to protect your business assets and handling incoming, current, and departing employees, and all the crazy situations and difficult situations that can arise that way. And I have the pleasure, and have had the pleasure of working with Chris Parker for 11 years now. So Chris, you want to introduce yourself?
Good morning, everyone. Thank you again for coming. Like Dan, I've been with Michael Best now for 11 years, as Dan mentioned. I've been practicing for about 15 years now. I'm more of just a straight litigator, and I focus my practice in commercial litigation as well as employment litigation. Our client base is manufacturing based, or also banking, as Dan mentioned, hopefully what we'll talk about today will be useful to you and to your clients as they go forward. So,
okay, everyone ready? All right, we'll put that aside, and like I said, we'll come back to the quiz later. We're going to go through now PowerPoint to hopefully impart all the knowledge that you need for that quiz. After this, we'll go through a scenario that'll also go through some scenario that really simulates some real live situations we've encountered in our practice. So let's jump right in. Protecting your business, best practices for handling incoming, current, and departing employees. What do we mean by that? Well, let's talk about the big picture of what we're talking about today. What you do in terms of bringing on employees and hiring them, how you handle your employees while they're with you, and how you handle the employees on the way out are all critical to protecting the business interests and the assets of the company. Your confidential information, your trade secrets, your customer relationships, your employees, those are all assets you spend a lot of time and money really investing in and trying to build and develop. And we're going to be talking through about a number of different laws today that really have an impact on that. And many of you probably have heard about the idea that there's a public policy that says that employees should be able to move around, go from employer to employer, earn a living the way they want, earn a livelihood the way they want. And we'll talk later about certain types of agreements known as unfair competition agreements or non-compete agreements that can restrict that public policy. And we'll talk about when those can be in play and when they can be enforceable or maybe not enforceable. But there are also, aside from those sorts of agreements, there are a lot of laws that can restrict what employees can do. There are computer laws. There are fraud laws. Brian and Chris and I were talking about fraud before we started. There are laws that govern what kinds of information people can use or not use or disclose. There are laws that relate to someone's employee. Every employee has a certain duty of loyalty to their employer. If you're high enough up in the company, you have a fiduciary duty to your employer. So there's a whole host of laws that relate to what employees can do while they're working for you, what you can do as an employee while you're working in a company lawfully, and then also what you can do after you leave or what you can do on your way in. So we're going to touch on all that. And one thing we'll spend most of our time on, two items. One is trade secrets, and Chris is going to touch on that just in a moment, what those laws are. And you may be surprised to see how much those come into play into your day-to-day lives more than you probably thought. And we'll spend a lot of time on unfair competition agreements to talk more about what those mean and all sorts of nuances in the law related to that. So Chris is going to jump in with trade secrets and what those mean and what their impact is in your day-to-day lives in employment.
Right, and thanks, Dan. And please feel free, if you have any questions as we go through, to cut us off. You know, we want this to be as sort of free-flowing as possible. But So one of obviously the areas of importance is protecting, your business or your client's business, their trade secrets. And what do we mean by trade secrets? Well, here's a real mouthful, but this is the technical definition of trade secrets under the Uniform Trade Secrets Act. So I'm going to read it here, and I'll do it without trying to take a breath. But technical or non-technical data, a formula, pattern, compilation, program, device, method, technique, or process that derives independent economic value, actual or potential, from not being generally known to and not being readily ascertainable by proper means by others who can obtain economic value from its disclosure or use. Obviously, again, that's a real mouthful, but what do we really, or what do you or your clients really need to consider when protecting or trying to ascertain what might be a trade secret with their company? I think the important takeaway, because really trade secrets is almost sort of an after-the-fact determination, probably made by lawyers in a lawsuit or a fact determiner, the judge. But from a company perspective, I think what's important to keep in mind is what would be confidential. What do you consider confidential? What do your clients consider confidential? And if you can keep that sort of as the guidepost on determining what trade secrets you have in your company, that's a good, helpful way to actually define within your company what may be a trade secret. The key is also, it's something that's not easy to replicate, and it's something that is not readily ascertainable by proper means. So again, it goes back to sort of the confidentiality. Something that your business has created or your client's business has created, developed over years, that isn't available to the public or isn't available to others, through, that aren't attainable through proper means. The other key here is, it's also something that must be subject to reasonable efforts, to keep the secret. So your company, it can't be something that you just keep confidential, but you actually don't make the effort to keep it confidential. So what do we mean by reasonable efforts to keep something a trade secret? Obviously, there's no set formula for reasonable efforts. There's no, I sort of liken it to, and maybe I'm dating myself here, but the old opening to the TV show Get Smart, when he goes through all those doors and there's the music and he keeps going through these doors and he eventually goes down a telephone booth. That's not what we're necessarily talking here. There's no one set, secure way to make sure that you did the proper methods to keep something reasonably secret. So it's going to be a fact determination, but there has to be some sort of internal reasonable efforts by you or your clients to make sure that they've done what they can to keep things or certain items confidential. And that is a determination once it gets to litigation. So that's what courts will look at. What methods did you go through in order to keep something confidential? Now, there's also a balancing aspect to this. Obviously, you need to operate your businesses, or your clients need to operate your businesses. So when we're talking about reasonable efforts, there's the balance between the free flow of information among your employees or your executives versus the steps you need to take in order to make sure something remains confidential within that term under the Trade Secrets Act. So what are some common reasonable efforts? Well, a sort of a more common one and probably a basic one for everybody that they should implement is confidentiality and non-disclosure agreements. Certainly for a base level, for sort of base level employees, all should probably at least engage in some sort of confidentiality agreement with your company or your clients' companies. The sort of non-disclosure agreements are also very appropriate, and probably more at maybe a higher level employee. But these are great ways, obviously, to ensure that you're at least taking the steps to keep some secrets confidential. What other security precautions can you take? And a lot of your clients and a lot of your companies already have these, but it's another thing such as locks. As simple as locking a cabinet file. Now that's probably getting a little dated, but to those of you who still use cabinet files, it's good to keep it locked, to mark it as confidential. Obviously now with everything being electronic, obviously passwords, our firm has dual login systems where, as much of us have complained about it, it's good to, actually go through multiple steps when you're logging in with, accessing through your phone, etc. Badges, certain sections, obviously, of your companies, only restricted to certain people who have certain badges or certain approval. Again, login screens, that's something similar to using passwords when you're logging into your computer, or even login screens when you're accessing certain topics of documents or other information within your company. Policies regarding electronic communication. Obviously, this is becoming more and more important for all our companies and our clients. Monitoring, having a policy in place that informs the employees when or what can be used for electronic communications, not sending out information that would be deemed sensitive to because once it gets out there, obviously it's something that everybody would have access to. That would be something that would weaken your ability to claim it's confidential. Social networking policies is obviously a developing area. Having a policy in place that informs the employees that you can't just put information that the company may deem as confidential out there. Once it is, it's going to be hard to sort of pull that information back and to claim somehow you're keeping it confidential. Handbooks, it goes along with a similar type of policies we're talking. Implementing policies, implementing handbooks that explain to the employees what our policies are. And have your employee probably sign the handbook annually to make sure that you're actually going through the hoops you need to go through to remind the employees that we value our confidential information. Need to know, sort of similar to the approval process, keep certain materials, keep certain information on a need-to-know basis for certain employees. I think the important thing to remember is, too, there is no single sort of process to go through to determine what would be reasonable efforts, but a key is probably redundancy. Not just one single method, not just, at the beginning of an employment relationship, you have them, sign off that they'll keep things confidential, but to do it, to have reminders, to have additional steps. That's what the courts are going to look at to make sure you've made the reasonable efforts.
And actually, as Chris mentioned, it really is, this is what courts look to. Let's say you want to enforce, you think someone's now stolen your trade secrets. So let's say, for example, they stole your customer list, and it's got all pricing information on it that you think is really something that's rises to the level of being so treasured and special to your company. It's not readily ascertainable. It's something you really think is a trade secret. So you get into court, and I've had this happen in a case, and you'll submit documentation. It could be affidavit or whatever, and you'll say, we've taken the following steps to keep these trade secrets confidential. And hopefully, like Chris said, you've got a lot of steps you can articulate that'll show redundancy, how important it is. But I literally have had a judge ask me in court, and this was for a bank client, saying, well, do they keep the information under lock and key? Are the file cabinets locked? Is it password protected? Do only certain employees have access to it? Those who have a need to know. It goes back to Chris was saying on a need to know basis. The hard part, again, as Chris said, is the balancing act. If we were living in just the legal world, the litigation world, you would take all these steps, and be a burden, but it would be hard to conduct your business, right? I mean, it'd be like, so you kind of have to balance a little bit, but know that, and I think sometimes what happens is this is where companies will fall down, or banks will fall down in this process, which is they may have something that really rises to the level of being a trade secret, but they haven't taken the steps to actually keep it confidential. So it's a couple of things. One, you've got to have something that really rises to that level, but then also you've got to take the steps to keep it confidential. Otherwise, it's not going to be protectable. And judges will really examine what you've done to keep it. It's like how much time and energy and resources you invest in keeping this information confidential.
So, typically what are some examples of trade secrets? Obviously customer information, and probably, this is not new probably to you or your clients. Cost margins and profitability information, formulas, methods for making products, codes for determining discount, rebates, or other concessions, and a price list or catalog. These are things that you've developed as a business that aren't readily ascertainable by the outside or by competitors, that you've spent man hours, years developing, that the last thing you need is somebody walking out the door with this type of information. Things that the courts will take into account when again, sort of going over a little bit what we've already mentioned, but to the extent that the information is known outside of the company, to the extent it's known with your own employees. If things are limited, if you can demonstrate that things are limited within the company, that's certainly a good way to indicate that something's a trade secret. I mean, if you've gone to the efforts to limit within your own company, obviously it's something that shouldn't be known outside of the company. Again, the measures, courts will look at the measures you've taken to protect that information. The value, another thing to look at will be the value of the information, that if it did get in the hands of somebody else, what is the value? Is it something that would be very helpful to competitors or others outside your company? Again, the amount of effort that you spent, the amount of money that you spent safeguarding these are all factors that courts will look at. And then certainly another factor is sort of the ease and difficulty of gaining this information outside of the company.
Chris, can I?
Yep, go ahead.
Can I ask you a quick question if you go back?
Sure.
With respect to customer information in particular.
Yep.
So if you were a manufacturer and you have a sales guy who is calling on lots of accounts, that those accounts, those companies are essentially public, information, right? I mean, you don't necessarily need to work for that company to know those customers, right? So how do courts look at that in terms of, well, yeah, the person could leave and they could open the phone book and and look and call on those companies, but essentially, are they really trade secrets? Is it in how you use it, how you approach the customers, or because you're in that particular business? I mean, what makes that customer information?
And that is, I mean, that's really sort of a common probably situation, and the short answer is it depends, right? I mean, it does. It depends on what efforts you've gone to protect that information. But you're right. I mean, it's going to come down to, look, the person who's leaving is probably going to say, well, I talked to those people individually before I came here. Why do I need to, why is it somehow something that's protected, from my prior company? And that may not be. I mean, it may ultimately be something that, you're right, it is publicly ascertainable through common means that they did have. But it's again, it goes into sort of you as the company will need to demonstrate to a court what steps did they go to protect that. They may have gained that information. They may have had a little bit of it or some of those clients before. But if you can demonstrate, look, we've developed this over 20 years. We've made our formulas based off of these customers, based off their pricing. It's the hoops that you've gone through as a company in order to demonstrate why that's something that should be protected. But there's no question, I mean, that's probably, the fine line, and that's what is going to come down to what the court's going to determine.
Just a list of names, if
Right.
anyone can get those, through what we used to say was a phone book, but that's not going to be usually protectable. But then what you get is you drill down, as Chris was saying, in more specifics. Have you over a number of years gathered a lot of data about pricing information? What the price point is of the, for that customer, and have you actually gone so far as to, in any documentation with that customer, indicated, this is a confidential agreement or something like that, protect it that way, and how much is it readily ascertainable to anyone, and how much has it been really developed over years through a lot of specialized relationship and really cultivating that, so that someone couldn't take that information, hit the ground running, and take unfair advantage of all that time and effort and money that's been invested to try and build up that information over time. Okay.
So it's not the customer name or even a customer contact at the name, because you can get those on LinkedIn or otherwise. You're just talking about sub-level information from that.
Yeah, I mean, I've actually had a case where someone claimed, though, it's also that they tried to say that the contact person was confidential because, anyone can call on companies, but to get to the right person. But that's usually a tough stretch because I think, without too much trouble, you could probably get to the right person usually. But you're right, it's more as you get down to the sub-level information that you can show it's something that's really been developed and is not just something anyone can easily get or duplicate. Yeah. Ike, go ahead.
Yeah, but if you, or could you have a policy in place for departing employees, a policy that they would be prohibited from contacting any current customers that you have, even for somebody who they dealt with prior to coming to you, the fact they work for you now, could you have a policy that says, like, for the next 6 months, 12 months, whatever, 18 months, you're prohibited from contacting that particular vendor or whoever?
Yeah, actually, we'll touch on that shortly, but aside from, instead of just a policy, we would recommend an agreement. So you'd have an agreement, it'd be a form of an unfair competition agreement, and we'll talk about those exactly. That's really a way we recommend to try to safeguard the information.
So I guess, talking about litigating and law and trade secrets and safeguarding information, but if you've got a first-year employee that gets his hands on a price list and gives it to a competitor, what's there to litigate? You sue the guy who doesn't have any money, or are you suing the company that got the information and should not have used the information?
Yeah, and actually that sort of dovetails pretty nicely into that. Thank you for the lead in there. Yeah, right.
That's good. You guys, well, Ike's got a great segue there, and you got one too, so thanks.
We planted you.
Yeah,
yes, right.
You guys are coming through. Thanks.
No, but I mean, to sort of directly answer your question, I mean, there are protections. To the extent the next employer uses that information, they can also be found liable. Yeah. Yeah, exactly. And that's under the Uniform Trade Secrets Act, which is, provides which is the bench post for 47 states and the District of Columbia. They've adopted it. It's the national policy. 47 states have adopted it. Actually, North Carolina, I think, has a state statute that's very similar. So most, if not all, the states have it, and they provide remedies for you as the person or the company that lost that person, and if they use that, you can go after that company. Now, damages is always an issue when litigating, and how do you prove damages? And I probably don't have to tell everybody in this room. So you would have to then demonstrate, did they use it, how they used it, what type of revenues were lost, that sort of thing. But it will make that employer liable as well. And then not only, one other point on the Uniform Trade Secrets Act here is not only is it just for, remedies for an actual misappropriation, but even the threatened misappropriation. So you can go on, and if they took the list, they haven't used it yet, certainly, but it's something, it would be a preemptive, get some sort of injunction, get something in place that they're not going to use it. So, and it's easier said than done in actual litigation, and it's always a business issue. But the earlier the better, obviously, to the extent you can get your hands on it, and they took it. It's probably better to be up front and get something, on file and seek some sort of immediate remedy in order to protect it. Again, some case law here regarding trade secrets and vicarious liability. This is, again, exactly to your point. These are some of the cases. And there's been more recent ones that have actually followed these holdings as well. The Newport News out of the Eastern District of Virginia, finding vicarious liability to be available under the Uniform Trade Secrets Act based on respondeat superior. Again, they're going to find that the next employer liable for any misappropriation if they use that information and if you can demonstrate they used it. Similar to the Thola case, finding a future employer may be vicarious liable if it knowingly benefits from the employee's tortious conduct. So there is law in place. Obviously, it's always easier, in concept to prevent that from happening, and the actual effort to do it may involve some litigation, but it's out there.
And if found liable, that employer who benefited from that unlawful, use of the trade secrets would be have to return what are referred to as like ill-gotten gains, unlawful profits that they received as a result of the unlawful use of the trade secrets.
Can I ask a question?
Sure, Brian.
But in the situation where the employer maybe doesn't know that this new salesperson, is that the first case there where they're, what protections can an employer put in place to avoid that, to defend that type of claim?
Yeah, well, that's a really good question, and we're going to get to that shortly. We recommend when you hire employees that there are all kinds of questions you ask them and instruct them not to bring any information that is confidential or a trade secret, and we'll talk about it, but you really have to pound that, emphasize that. If they don't know, they can make an argument, look, we instructed them that, about this, and this upon hiring, and that sort of thing, and then we absolutely told them we didn't want any of that information to be used here. So it's a good way to try to help the employer insulate itself. Bruce?
And I was just going to add on
Yeah.
to that. So when I joined Kaufman, my previous employer, I've been there for 27 and a half years. Upon leaving, I didn't tell them where I was going. So we went through 90 days of fun. Anyway, when I joined Minolta, they did have me sign documents saying that I am not bringing anything to this organization.
Yeah, that's optimal. That's really what we recommend. And if you don't mind, I'm just curious, did that bother you to have to sign that? Was that surprising? What was your reaction?
No, especially what I was going through on the
Yeah.
departure.
Yeah,
Seeing what they were doing with me leaving the company. Actually, many people had started leaving already, I think, and I already knew this being there that long, I was going to be the sacrificial lamb of, going after this guy, but I left with nothing. I guess that was the frustrating part is I didn't leave with anything. And then you were talking about the non-compete. Yeah, 1 full year before I could go back.
yeah, okay.
And after that many years, many of your customers and clients are, sure, they're on here, but they're here.
Right.
Exactly. Yeah, we'll hit on that exactly. The incoming and the departing employees, is exactly your situation, which unfortunately you had to live through, but it sounds like it had a happy ending, so.
Yeah.
And it sounds like your previous employer actually had good counsel. It must have been Michael Best,
Yeah, that's
who was representing to make you go through all. I know you don't like us
Right.
lawyers in those situations,
My
but
question is,
Yeah.
after all the threatening FedEx letters and drop-offs, and if I had, and which I didn't, I hired an attorney, but if I had just ignored that and didn't do anything, what really could have been done?
Yeah, you mean against you,
Yeah, I mean,
right?
no.
So one thing that they would assume or hope that they have a well-drafted agreement that would be capable of being enforced, and we'll touch on more about that. So they could have filed a lawsuit against you, and they could have gone in on an emergency basis. Chris mentioned, in this situation, like if you're going to do harm, well, if they thought you had trade secrets, they could even go ahead and think, okay, you haven't done harm, but you think, you have threatened misappropriation. Bruce has all this information, whatever. But they could also say, Bruce is now, let's just say, for example, soliciting our customers, or Bruce has a non-compete, which said he couldn't go work in the related industry for a year, let's just say, for example, and they thought you were going to do that. They could file a lawsuit to try to prevent you, to enforce their agreement against you, a non-compete agreement, to keep you.
Most of the verbiage was, we're under the assumption that you're doing this. You've got trade secrets.
So, yeah. So they would have to prove that. And we'll go over at the very end, the last slide, like what does that look like, that emergency procedure? But they would have to prove it and show that there were trade secrets. They'd have to show that their agreement was enforceable. And your lawyer probably helped you analyze how well drafted you thought maybe the agreement was and what your risks are. And frankly, we get involved on both sides. As we get involved with our employer clients who are trying to have employees leave and they want to, let's say, enforce an agreement against someone who's left, or trade secrets they feel are being taken. And we also get involved when clients are thinking of hiring someone and they have agreements or they're coming over, and we counsel them on what to bring or how be careful not to make a hiring decision that will cause the employee to violate their agreement they've got. So, but the key is we'll hit on this upfront analysis of these situations, because they can be, for example, for you, so you could have been a defendant in a lawsuit. It's no fun to be, have your name and a lawsuit as a defendant. And back to, is it Eric?
Yeah.
Back to Eric's question, your new employer, kind of like Minolta, could have also been a defendant, because they could have decided, let's hook them in too, because we think that they're going to benefit as well, okay, or they have already benefited. So.
Yeah, and it sounds like, obviously it sounds like your previous employer was a pretty aggressive, obviously, approach. And for your companies, that's the balance. How aggressive do you really need to be? Given your 27 years of experience, I think they probably felt you had a ton of information that could ultimately be damaging. But there's the business, because that's a cost, right? They've got attorneys already involved before you've done anything wrong, and you weren't, but
Yeah, and I think a lot of it was people were starting to leave, and then when you get, people with less tenure, but then who knows, so you've got new people on board, and you see somebody that's been there that long leaving, they kind of wanted to stop the hemorrhaging.
right, and that's, you were probably made an example on some levels, and that is the business, that dynamic here, that every company has to go through. How important is the information, that an employee has? And we'll get into this, sort of your analysis that you go through as a company. Is it worth it? Because there is costs, obviously, for them to even do that.
Yeah, and I think, the employment relationship in general is really emotionally charged, and these situations get very, very emotionally charged. If you get, let's say you've got an employee, let's say they train you, and they think, oh, now I spent all this time training Bruce, I developed them, I even gave him some leads, whatever it is, and now Bruce, for all we know, is leaving. Maybe he's gotten a whole group to go with him, and it gets really, first of all, some of it's viewed as a threat to the business. And it's also really emotional too sometimes, because look, after all we did to help develop and grow Bruce, and now he's taking his whole team with him. So these get to be pretty heated battles, actually.
Yeah, just one
Yep.
question on this issue.
Yeah.
If the company didn't require you to sign anything coming in, can all of a sudden now, when you're leaving, all of a sudden I may manufacture something and say, oh, we need you to sign it?
That's a great question.
If you didn't agree to sign anything when you came in,
Yeah.
how do you just all of a sudden now, if I've been here 27 years, you manufacture something, but you got to sign it?
Yeah, wonderful question. Yeah, you don't have to sign anything. We're going to talk about the situation. Let's say, we'll talk about this shortly. You guys are hitting on all the really interesting key points, but
We won't need to go through the other
it's amazing.
slides. We'll just-
So let's say you've been working somewhere, not that, Bruce, you're going to be our scenario for now, but Bruce is working there for a year. He comes in, he thinks he doesn't have to sign any agreement. He came in. A year into his employment, they say, hey, Bruce, now we want you to sign an agreement that restricts what you can do after you leave. We'll talk about what an employer has to do to make that enforceable. And there's some really recent changes in the law in Illinois because that changed your circumstance, right? You didn't think that was a condition of your employment, but now they're coming to you and saying, now, to Ike's point, now it is. But on the way out, certainly you could say, no, I'm not signing anything. I don't have to sign anything. There's a nuance to it. Let's just say you were terminated, or let's say there's a reduction in force. Let's say this whole division is closed down, and they're going to give you severance pay. and as part of the severance pay, they want you to sign a separation agreement. And let's say as part of that separation agreement, they fold into it, and by the way, you can't solicit any of our clients for a year after that. That's a situation where, you don't have to sign it, but you may weigh, if I want the severance pay, I see that this is a condition, so you'll balance whether you want to sign it, get the severance pay, and have his, be restricted what you can do afterward, or just not sign it and not get the pay and be free to do whatever you want.
It's really a backdoor way to extortion.
What's that?
It's really a backdoor way to extortion.
Well, we wouldn't call it extortion, but
Really, it's saying, if you want the money,
yeah.
you better sign.
Well, the condition.
It's called consideration in the law.
Right.
But I mean, the key is consideration,
Yeah,
Dan.
right.
Because you're getting some sort of benefit in return, they can actually, have you give them a benefit.
So in Bruce's example, he was terribly frustrated, but the company did everything they should have done. Right?
Well, I mean,
Sorry.
without knowing
Yeah.
what actually you had to go through, I
Right.
was sort of being glib by saying they were good attorneys.
And
But
in my previous employer, after all, they would, I want to say it was maybe every 3 to 5 years, would actually have a new non-compete that you would sign.
Oh, okay.
That, there might have been some more verbiage, there might have been some additions in there. Probably as, some of these laws keep changing, they would actually change their non-compete and have it updated on file.
well, and Dan will touch on this. I mean, some of those may not be. There has to be consideration
Yeah.
given. They can't just sort of make you. You have to be given some sort of consideration, as Dan already touched on. Whether it's extra monetary, benefit,
Because it's what.
promise of
yeah.
employment, although continued employment isn't actually.
Yeah, I mean, the concept is you're giving up, when you sign a non-compete, you're giving up some rights for what you can do, after you leave. And so they should give you something, otherwise I would call it extortion. So.
Just a substitute consideration for extortion.
That's right.
Yeah, right. Well, quickly, we've already touched on a lot of these, but some just sort of, what you can do to safeguard the theft of your confidential or electronic data. Inventory is actually one of the things I want to touch on here. Inventory your confidential information. I mean, you've got a lot of moving parts in your business or your client's business. So it's important to sit down with the appropriate people in your company, maybe with outside counsel, maybe, just people, everybody who may have, knowledge of certain confidential, and take an inventory of what you believe to be confidential information or what your company thinks should be kept confidential. A lot of because a lot of it's organic and, things are moving fast. So it's important to actually go through the inventory process about what may be confidential. Establish, access protocols. Again, we've talked about this. Make certain things on a need-to-know basis, and how you access that information. Whether it's, locked doors, whether it's passwords. Keep the system password protected. Make all confidential information and trade secret again on a need-to-know basis. Lock out employees. So this is sort of, at the end of an employee's relationship with the company. Make sure you lock out, once they're terminated, make sure you lock out the employees from the electronic communication system upon their termination. Get their password, get their information. Make sure that they, are scrubbed from your system. And I'm not very technologically savvy, so I don't even know if scrubbed is actually the proper word. But I think you get my point. Rely on your systems people, obviously, to help you with that process. Recover any sort of, if they have a company phone, obviously. If they don't have a company phone, but they can access your email from their own phone, which is how I'm set up at my, make sure that you've scrubbed that from their phone. Make sure you get assurances at the very least that the information has been deleted or destroyed from their personal data, from their home computers. It's a tricky situation, but make sure that you can get access to, and this can be something that you can put in your original agreement. Have them sign confidential agreements that allows you, if they can access their work, their work system through their home computer, that at least the company has the right to go into their home computer and be able to access that upon their termination in case they've downloaded improper information. And now we're getting into sort of the unfair competition agreements, which we've already touched on.
Yeah, and so unfair competition agreements, there usually are two myths. I mean, one is that they never can be enforced, and some people think, on the other hand, they always can be enforced. And sure enough, like a lot of things in the law, the reality is somewhere in the middle. A lot of it depends on how well they're drafted, depends upon the specific facts and circumstances. I've actually been in court in front of two different judges with almost identical circumstances with identical agreements and got two different results because it depends on the judge sometimes too and how their interpretation of the law and the facts. So when we talk about unfair competition agreements, let's just make sure we know what we're talking about. Sometimes you'll hear people say non-compete agreements, and they're kind of using that term loosely. It can be everything from, as Chris mentioned early on, like a confidentiality or non-disclosure agreement where you won't disclose confidential information of the company. Another layer could be a non-solicitation agreement, which means, after you leave, you won't solicit the company's customers, or you won't solicit the company's employees. A third and most restrictive layer could be a literal non-compete. After you leave, you won't go work for a competitor, let's say for a year, something like that. So these are different forms, and employers have different, some have all three as part of one agreement, some have separate agreements. There's a lot of strategy in this. But in general, what they do is, unlike most contracts, because it's an agreement, it's a contract, to try to make it be enforceable, courts look to see whether there is a protectable interest. Because remember, I mentioned at the outset, in general, there's this public policy that people should be allowed to go work where they want to go work, have free to earn a living the way they want to earn it. And these agreements restrict that because they say essentially that after you leave, you can't go engage in certain activities. And so sorts of protectable interests are like long-standing customer relationships that a company wants to protect, or their confidential information that they built up, spent a lot of time to build up, and they want to protect. And there's some other interests as well, like goodwill. Often these agreements will have certain restrictions, and the courts will look at the scope of the restrictions. How long are they in place? Are you trying to say that someone should be restricted from engaging in certain activities for a year, or 2 years, or 3 years, 4 years, whatever else? So there's different ways that can be too broad. And what's the scope? Are you saying you can't go work for any competitor? Or are you just saying you can't go solicit our current customers? Or are you saying you couldn't go solicit current and prospective customers? Or are you saying you can't go work anywhere in the United States for any related business? How broad these are influences whether or not they're going to be enforceable. In general, the courts try to be fair to employees and keep in mind these public policy considerations. The context of the agreement matters too. So was this entered into when, let's say, Bruce began his employment? Was it entered into when, let's say, your company got acquired? And the company that acquired your company then said, now we want all of our new employees who are going to become employees of the company that acquired your company to sign unfair competition agreements. In the context of a sale of a business or an acquisition, courts are more prone to enforce these agreements because they'll see it as part of a transaction, part of a negotiated transaction. The more common scenario is that when someone begins an employment relationship, we'll see them commonly asked to sign an agreement, or perhaps after they've already been an employee, all of a sudden that employer will decide we want to now have our employees sign agreements. The reasonableness of these agreements really matters tremendously. Courts will look at how reasonable they are. If you're preventing someone from working anywhere in the United States, for any kind of business that might be related, that's very vaguely drafted, it'll be really hard to enforce it, unless it's a certain type of business that is unique and they do business around the United States. If you're preventing someone from soliciting any prospective customers for 5 years, even prospective customers that the salesperson never dealt with themselves, courts are going to be less apt to enforce that. It's important to make these agreements as reasonably drafted as possible, as narrow as possible to try to meet those protected interests. So if let's say in Bruce's situation, he left and he had signed an agreement with his former employer and he hires a lawyer, the lawyer is going to look at how well drafted that unfair competition agreement is. If it's ridiculously overbroad and unreasonable, there's less of a chance that the court will enforce it, at least on its terms. It may, we'll cover this momentarily, try to narrow down the terms. If it's a horribly draft, we get asked that a lot. Will you look at, we're about to hire this employee, will you look at the agreement they have? How capable of being enforced it is? And we can look at those really quickly and give you a sense under various states' laws how enforceable or capable of enforce it would. If it's horribly drafted or if it's way overbroad, it does a disservice, basically. So our point is don't be greedy, make these as narrowly tailored as possible. So how many of you have do business in multiple states, your companies? Okay. So each state's law varies in this area. These are governed by state law. Your very first question in your quiz, I think, was federal law.
Martha was wrong.
Okay, yeah, you're not the only one. So it's state law, and one common pitfall that companies make is that they'll do a couple things. One is they'll have one agreement that applies to all states, and they'll say, like, Wisconsin law governs all those agreements. Well, Wisconsin law is not as favorable as Illinois law in certain respects for these agreements. In fact, we were in an unhappy position of, and we didn't draft the agreement, but our client won, someone left, let's enforce this agreement, let's go. The employee was now working in Illinois, and we sued in Illinois. We had to sue in Illinois for a variety of reasons. And the agreement said Wisconsin law governs. And in Wisconsin, if an agreement is overbroad, let's say it says 5 years, and the judge says, that's ridiculous. Keeping someone from working for a competitor for 5 years, that's way overbroad. That doesn't satisfy any protectable interest. Reasonably satisfy it. Maybe 1 year or 2 year would be reasonable. If it's anywhere overbroad in Wisconsin, the agreement's unenforceable. So we argue, well, Illinois law should apply, despite the fact that the parties had chosen Wisconsin law. It was a problem. So one takeaway from today should be, first of all, how many of you have unfair competition agreements? Like, either non-solicitation agreements, confidentiality agreements, non-compete agreements. Okay. One takeaway from today should be, look at whether those agreements say a certain state's law applies. If they do, it's important to evaluate whether you're being strategic about that. When we have clients who do business in multiple states, we'll draft what we call, refer to as common denominator agreements. This one covers these 5 states because they're drafted to be compliant with that state law. This covers another 5 states until we cover all the states. But we're strategic about which state's law will govern. So that's one thing that's really important. We talked about consideration. Ike calls it extortion. What it really means, basically, again, is when you enter these agreements, you're giving up rights. So you have to be given something in exchange. So what happens when you begin employment? It used to be in Illinois, and I'm going to cover this case momentarily, that if you were told, okay, here's your offer letter, and here's what you're going to get paid, and here's how many vacation days you get, maybe something like that, and sick days, whatever. And also, as a condition of your employment, you're going to be required to sign this unfair competition agreement. Going in, eyes open, that's one of your conditions of employment. It used to be that was fine under Illinois law. There's this recent case that's thrown that totally up in the air. But in many, many states, that would be adequate consideration. It's one of your terms of employment. In many, many states, if you're already working, let's say for a year, you have no unfair competition agreement. Someone comes to like Bruce and says, now sign this agreement. They have to give you something in exchange for that because you're giving up rights. It could be maybe in conjunction with a discretionary bonus that you're not otherwise entitled to. It could be an additional amount of money. It could be some promotion, something that gives you more than you already had. That'll help make that adequate consideration to support these increased restrictions on what you can do after you leave. I mentioned the concept of, in some states, continued employment will be enough. So let's say that the employer comes to me a year after I've been working there and says, now we want you to sign an unfair competition agreement. We didn't before, but now we do. And I remain employed for 2 more years. That continued employment will often be deemed to be adequate consideration, even though they didn't give me anything else. The problem is when you ask an employee to sign something like that midstream, you don't know if they're going to leave 2 weeks later or a year later, or maybe not be there long enough for you to be there long enough to constitute adequate consideration. So blue penciling means that in Illinois, for example, is one of those states that will blue pencil an agreement, unlike Wisconsin. So if a court sees this restriction is for 3 years, that seems way too broad to satisfy the protectable interests. Their customer relationships change every 2 years. Their confidential information becomes stale in 2 years. I think 2 years is more reasonable. The Illinois courts have an option to narrow it down or blue pencil it to change, let's say, 5 years to 2 years or 3 years to 2 years. They don't have to. They may decide that it's so overbroad, this agreement, that it's ridiculously drafted, it's unenforceable. But they do have that option to narrow it down to make it more reasonable and enforceable. So let me cover a couple of key cases. One is, and the law has changed a lot. In Illinois, it used to be there were two protectable interests. One is customer confidential information, and two were long-standing customer relationships. And December 2011, December 1, this reliable fire equipment case came along. It was a case involving a salesperson selling fire equipment. And the court said a couple things. We're going to look at these agreements in terms of reasonableness. And if an agreement is signed in conjunction with beginning employment or employment relationship, it'll be reasonable if the agreement is tailored narrowly, only so broadly as to meet the protectable interests. If it doesn't impose undue hardship on the employee, if it doesn't cause injury to the public, those public policy considerations. And even more important, we're going to look at what is a protectable interest, what is a legitimate business interest to satisfy in these agreements. And the court really changed the law in Illinois on this. It said it can be near permanent, long-standing customer relationships. We already had that before. It could be confidential information the employee acquires through their employment relationship. But we're also going to look at other factors. It could be time and scope of the agreement. It could be the specific facts and circumstances. It could be other sorts of interests, maybe goodwill, trying to protect the goodwill of the company. And it could be the fact that no one factor really carries more weight than any other. We're going to look at the totality of the circumstances to see whether this unfair competition agreement really satisfies a protectable interest. So that changed the law. Then more recently, June 24, 2013, we had this Fifield case that changed this whole concept of consideration. Remember, in Illinois, it used to be that if Bruce were told that as a condition of his employment, he had to sign this unfair competition agreement, that's fine. He signs it, it's adequate consideration. Or if Bruce were told midstream, you have to sign this agreement, now, and he worked 2 more years, it would be adequate consideration. This Fifield case said, and it's an Illinois appellate court case, it said that it's not enough to tell Bruce as a condition of his employment, he's got to sign this agreement. We've got to give him something above and beyond that. We've got to give him additional consideration, like pay, for example, and say, we're designating this pay to match up with this unfair competition agreement we're asking you to sign. The Fifield case also said, though, if you do happen to work 2 years or more, have that length of continuing employment, that would be adequate consideration. The problem, again, is we don't know if Bruce is going to work 2 more years after he signs it. He could leave in 3 weeks or a year or whatever, and it won't be adequate consideration. So that's another takeaway from today is that we really recommend you look at, when you have employees sign these agreements, are you accounting for this change in the law in Illinois and really articulating consideration? It's a very unsettled area in the law. So unsettled that 2 federal court judges who have applied Illinois law, as they rarely should, came out with differently in looking at this Fifield case. One judge said, I agree with this kind of 2-year idea. If you work 2 or more years, it seems like that's illogical. I think that's what the Illinois Supreme Court is going to decide when it finally takes this up, which it will at some point. So I'm going to stick to this 2-year rule idea. Another judge said, no, the Illinois courts vary a lot in terms of like how long you have to work an employer for it to really be adequate consideration. I think this really should be fact specific, and there's no bright line rule. So it's really up in the air on this, but this is another area to look at.
And just an anecdote for those cases. It's funny because it's Judge Holderman and Judge Castillo. Judge Castillo is the current head of the district court in the Northern District of Illinois. Judge Holderman was the prior head of the district court. And Judge Holderman, in his opinion, actually references how much he respects Judge Castillo. But I'm going to rule the other way and find that there is sort of a bright line rule of 2 years employment. But on the 2-year employment, this is such a an unknown area now. I mean, there's a lot of questions of, if 2 years is the adequate consideration, what happens if an employee leaves at, 1 year and 11 months? And, the courts may actually say that's not enough consideration. So it is really sort of an unknown area that'll be developed, and it'll be ultimately the Illinois Supreme Court that has to address it. So.
Yeah, Jordan.
run into a situation kind of looking at this in reverse where, say the consideration, somebody, new hire, somebody's getting paid $100,000 a year, and they sign, it's got a non-compete or non-solicitation in it, and then later on, so that's the consideration, maybe they're there for 2 years, 3 years, 5 years, and then and this happened a lot in the recession, so the employer comes back and says, hey, we have to cut everybody's salary. And is that now, a unilateral change? Does the consideration that was given for non-compete, essentially it's either gone or cut down, the employee didn't bargain for that?
Right. Yeah, it's a really good question. Excellent question. A couple things. I mean, ideally, under the current law now, if you were drafting that, rather than just say you're getting paid $100,000, you set aside a certain amount of that $100,000 or pay more, signed to the unfair competition elements of that agreement. The employer might have an argument, though, in your situation that depends, continued employment maybe, despite the fact that there are these changed circumstances of a reduced pay. There are some cases where you argue changed circumstances. So it would definitely be a factor, and these courts will balance what we call balancing the equities. A lot of this goes back to fairness, and that will be a factor to take into account. You already got your pay cut. What's going on there, and the employer on the other hand would argue, look, we provided adequate consideration. It doesn't mean it's unenforceable.
And it would go to reasonableness. I think if they had a legitimate business reason, right? If you could demonstrate as the employer, look, we had to cut salary, or we would have had to terminate people. That may go, but it's going to be a fact determination by the court, unfortunately. It's a litigator's dream.
Yeah.
But it keeps me employed.
Yeah. So other takeaways are doing what we call like an unfair competition agreement audit, just like that trade secrets audit Chris mentioned. And actually, for trade secrets audit, I will mention, we literally have created charts and meet with clients, like what do you have, and what would be a trade secret possibly, and then what steps are you taking to protect that, and work through that analysis so you put yourself best position to protect it. Same with these unfair competition agreements. Do you have your employees, or do your employees at your company, or you recommend your clients to sign these agreements? We recommend you do. What state's law applies? Be strategic about that. Which employees sign it? Do all the employees in the company sign, or do only certain level employees sign? Or do certain level employees sign a non-compete agreement, but then everyone signs a confidentiality agreement? There are a lot of decisions that be made along those lines as well. And then also, again, not only do you have confidential information and long-standing customer relationships, but just like with the trade secrets analysis, courts will analyze what steps have you taken to protect those. And then the policy audit. How many of you have employee handbooks? Okay, so ideally in your employee handbooks, you'll have policies that will cover this. This is another takeaway. Is there a policy about confidentiality in your employee handbooks? There should be. Even if you have a confidentiality agreement you have your employees sign. Do you have a policy about when employees leave, they must return documents, company information? There absolutely should be a computer use policy. As Chris mentioned, there's been a much bigger issue about what authorized uses employees can make of company computers, and making it explicit that they should not have an expectation of privacy in their uses of the company computers, and they cannot use computers of your company or any storage device of your companies beyond the authorized use. And that how do you handle incoming and departing employees? You have a policy and practice for that. So let's talk about incoming employees. It mirrors the outgoing employees, which we'll touch on in a moment. First of all, it goes back to what Bruce was told. And so, is it okay if we keep? Okay. Is it bringing back bad memories? Okay. Thanks. So when Bruce was hired, he was told, "We don't want you to bring." In fact, he had to sign something saying, "You are not to bring anything confidential or trade secrets from your prior employer." That's ideal. His current employer did a really good thing there. At a minimum, employees should be instructed not to bring anything. We say it is impossible to be too blunt. It goes back to Chris's comment about be redundant about this too, because we have had all kinds of rationalizations. Someone will say, we say, well, we told you, or your employer told you not to bring anything. Yeah, but it was on I downloaded it on my personal device, and so I didn't think that was a problem. And literally that happened. Yeah, but these are just my own customer lists. They're not really, they're like a subset of the company's list, and so it wasn't literally, I didn't literally take the company's list. I took like only 30 of the names of the company's list. And these are all rationalizations we literally have seen that have been involved in litigation. So it's also important to tell the supervisors they need to be on board with this, to be aware, to tell and reinforce this, that employers are not supposed to bring this information. When you hire someone, you really need to know what, if any, unfair competition agreements they've already signed. Because you're obviously asking them to perform certain duties. Maybe you think this is great. This employee's, I can tell they're going to be a top salesperson. Phenomenal. They've got a great track record, and they can hit the ground running, and then they come and you find they have a non-solicitation agreement where they're not supposed to solicit any of the customers of their former employer for a year. You don't want to be surprised by that. You also don't want to get in a situation where you're now all of a sudden becoming implicit somehow. Maybe you find out, counter to Brian's scenario where the employer does know, and maybe you find out and you're kind of implicit and you think, hey, this is great. We're just reaping the profits here. This is great. We're benefiting from all those client relationships that he had. And then the next thing you know, back to Eric's situation, you're getting sued as the employer too, and not only the employer. So find out what do they have, how well drafted are they, what intellectual property, what trade secrets do they have. And then on the out, when employees leave, what you do and what you say are really important. First of all, if you do have unfair competition agreements, you really need to reinforce that. We are reminding you that you have signed an unfair competition agreement, ideally when you began your employment. We at company XYZ take that really seriously, and we expect you to comply with that agreement. You are not to take any company documents. Have you returned all company documents? You can't take your laptop, your company laptop, nothing like that. You can't, anything like that. And you also want to preserve data. So anything like get the laptop, the desktop. Now what we recommend, here's a common flaw. Let's say an employee leaves and the company's suspicious. I think they're going to go work for a competitor, and I think they're going to take our information, our secrets, our confidential information. So I'm just going to go into their laptop that they use, their company laptop, and I'm going to do some searches to see what they did. That's a no-no, because what you're doing there is you're playing Get Smart, basically, back to Chris's lane, and you're doing your own little detective. You're kind of disrupting the evidence. What we recommend is you take that laptop, if you can, and ideally quarantine it, impound it, don't use it, so you don't tamper with it at all. And you can see whether this is a situation where you need to look into that, or if you know it is, you can always have a computer expert image the computer for maybe like around $500, no big deal. But once you start playing around with it yourself, you kind of disrupt the chain of evidence. And so this is a common flaw that employers will make. You're looking for every sort of device. We've seen all kinds of horror stories. One situation we got involved in after the fact, unfortunately, was that, and I don't know what part of this he thought it was a good idea, but this employee basically, before he left, he downloaded a lot of customer information. It was confidential, no doubt about it, of this company. And then he realized, okay, this was a bad idea after he left because he was going to work for a competitor. And so he did a data dump. He literally dumped his laptop in a dumpster. And somehow that became known. And so what happened, and we were unfortunately defending his new employer, which meant we had to kind of ride along with his new employee and try to resuscitate this guy. And so I kid you not, in court, then this employee signed an affidavit, and everything he did at that point, there was no way in the world that that judge was going to give that employee the benefit of the doubt in any fact-specific analysis or any interpretation of the law. And it was an uphill battle. So there was a data dump. We've seen a situation again where someone just, I'm going to just download it to my own personal device before I leave, and mistakenly thinking, well, I'll delete everything. Well, you all know by now nothing's really deleted, right? I mean, it's usually backed up somewhere. So, and we've been able to find amazing things that are done on computers that really nail employees who are breaking the law, basically. So watch out for those things. So basically...
Yeah, so, this is what I like to call the advertising section of the presentation. What are some proactive steps? Have counsel conduct an audit. It is important. Obviously, whether it's Michael Best's attorneys or your current attorneys, have them come in. They've, Dan has seen all sorts of scenarios, so they know what to, so they know the processes, they need to, they know what to protect, how to do it. Sit down with your counsel. They can determine what's confidential, what may be trade secrets. Again, we've talked about these steps, so I don't want to belabor it, but take the proper steps to protect those assets. Review the policies. The attorneys can review your policies. Make sure that, to the extent that you have restrictive covenants, make sure they meet the requirements of the state that you're sitting in, or, if you have other, if you operate out of other states, that they meet the requirements of those states. And, and this is one, too, that I meant to touch on earlier, but, train your employees, train your managers, train the people that you need to about these policies. It's one thing to put them in place, but it's another, to have one person who knows, oh yeah, well, we have this protected. But if your employees or the proper managers don't know about these processes, it probably doesn't do much good because they're not following them. So that'll be something that'll be used against you later. So, an attorney can come in and help you sort of organize and do what you need to do. The litigation calculus. This is always sort of, as a litigator, I always joke I'm the last person that a client always wants to call, right? Because, we're just expensive and, that means there's a problem. So it's important to obviously do a litigation calculus. You have an employee who's leaving, let's say, and you think they may be taking some sort of secrets, some sort of confidential information, violating their unfair competition. But do the analysis up front. Don't just call your attorney. Let's get a lawsuit on file. Let's make sure we go after this individual, because there's a large cost obviously involved in litigation, and once you go down that road, it can get expensive quickly. So what is the process though when you try and do that calculus? The key here is to balance what may be businessly reasonable versus what you should do in terms of litigation. And the initial, we can come in, or a litigator can come in and just, what we're going to do in the process is the first thing you're going to call us, we're going to come to your company and we're going to see what processes you have in place, what other employees, the individual who left may have talked to. We're going to do an investigation. We're going to go through your process. We're going to make sure that you're keeping it confidential, because again, if you haven't gone through these processes, it may not be worth, going down the litigation route. But also, from an actual litigation standpoint, probably the most effective way and the most important way is to get immediate remedy, or to seek some sort of emergency remedy from the court. That could involve a temporary restraining order, which is the initial remedy you seek from a court if you think that somebody has stolen some confidential information and they may be using it. The court can issue a temporary restraining order, which freezes or requires that individual to freeze their activity with respect to any affected information, and it has the force of a court order. Now, a TRO is only temporary. By law, it's only supposed to be in place for 10 days until you get what's called a preliminary injunction hearing, and that'll be a hearing before the adjudicator, the judge, and he will determine if there should be a more permanent type of injunction in place with respect to this employee. Preliminary injunction hearings can actually be pretty extensive. It's, you're generally putting on evidence, you're having witnesses, it is a trial, it is, an evidentiary hearing, and you're gonna wanna put on the necessary individuals that you can, again, demonstrating the processes that you went through, why this is reasonably protected. And then the preliminary injunction, as the process goes under law, it would be in place until what's called a permanent injunction hearing is held, and that can be, down the road. A lot of times it can be even a year or two down the road. And my always suggestion on litigation is it's going to be more expensive and it's going to take longer than you think. So it's really important to make sure that you do an upfront analysis and make sure this is the way to go. Again, you know, things to consider. What information has that employee maybe taken? If it's not the most important, if it's something you think may be reasonably accessible without much effort, it's probably not worth the effort. And you need to balance, you know, you need to balance your costs, your business analysis versus whether it's worth going to litigation. And you know, the other analysis is whether to finance the litigation for an incoming employee. Say you've got an employee, hopefully you've done your instruction at the beginning. Don't bring any information, don't use any information, we don't want it. But you know, the analysis should be you need to review the agreement you have with the incoming employee immediately after you may have notice of a prior employer. You know, and you can also enter joint defense agreements are a good mechanism if there are situations where you can represent the employee, but or actually have somebody else represent the employee, but you can also then enter into what's called a joint defense agreement where you can assist that employee, but you may not be taking the upfront cost of the attorney expense. That may be, you may want to push that back on the employee if it's important enough.
Okay, now let's go through, we'll move pretty quickly through the scenario. You should have it in your packets, hopefully. And we're going to read along and go step by step. But basically we have a scenario where we've got, the key players are,
I got it. Yeah, sorry.
we got,
There you go.
okay, the employee is Shelby leaving. We have HR director, and then we have Avery Good Life. So let me just read along. We'll take the first step. This is a case of Happy Corporation, Shelby leaving, and Bitter Inc., a very unhappy situation. In January 2012, Shelby leaving, Shelby interviewed for the Senior Sales Associate position at Happy Corporation, a manufacturing company in Illinois. During Shelby's interview, Happy's Director of Human Resources explained the job duties to Shelby and asked her if she had any agreements that might affect her ability to perform those duties. Shelby responded, "I know I signed some standard employee contract at Bitter Inc., my current employer, but I don't even have a copy of it, and it was all legalese." Shelby's interviewer responded, "Tell me about it. My wife is a lawyer, and she drafts contracts for the simplest of things, like hiring a handyman. You should see our prenuptial agreement." Shelby received excellent reviews as part of the interview process. As a result, Happy hired her as a senior sales associate, and Happy's HR director asked Shelby to fill out new hire paperwork, gave her the employee handbook, which had been updated 4 years ago. Several months later, Happy also had Shelby sign a confidentiality and non-solicitation agreement. Happy's CEO of Avery Good Life decided to welcome Shelby on her first day of work. He greeted Shelby by saying, "My name is A Very Good Life. On behalf of Happy Corporation, I'd like to welcome you to the team. We certainly look forward to utilizing your experience and all you learned while you worked at Bitter. I look forward to building a long-lasting business relationship with you here at Happy and working with you until you retire." So let's just break it there. We've got Shelby being hired. She's the applicant. Let's look at what happened. She had interviewed January 2012. She had some sort of agreement with her former employer, Bitter. She did sign an employee handbook, which was updated 4 years ago. She is asked several months after she begins employment to sign confidentiality and separation and non-solicitation agreement. The CEO said, "We're looking forward to utilizing your experience, and we hope you'll be here until you retire." Any problems with the way this was handled for this incoming employee? What do you think about the issue regarding her agreement with Bitter?
Clearly, there was something there. They probably should do more due diligence, try to find out what it was.
Okay, exactly. So she's got some agreement, and it sounds far-fetched as we read this now, but remember I talked about this idea of two myths. There are a lot of people who believe that these unfair competition agreements can never be enforceable, and many times there are salespeople who believe that. And so sometimes you'll see people kind of like, "Oh, it was so overbroad," or "I didn't even think, you don't have to see it. It's ridiculous." And there's a temptation to say, "Oh yeah, okay, forget it." But you're right. The employer has to do the due diligence on the way in to see whether Shelby can actually perform her duties that they want to perform in a lawful way. Okay, employee handbook is good. Go ahead, Jeff.
Does the company have an obligation to remind employees they sign something? Because you signed something 20 years ago, you don't know what you signed.
You mean the outgoing, the employer that they're leaving?
Active employees.
Every year or something.
Every year, like we sign antitrust things every year and other things.
It would actually be a good idea. Many employees do not do this, but it actually would be a good idea. Maybe you have things like that annually. We are reminding you also that you sign your unfair competition agreements as part of your employment with, what is it, Rock 10 or something like that. Because that would be a really smart idea, actually.
And as you you can tie it into, sort of updating handbooks, you hand it to, your current employees. Oh, re-sign this, also don't, you could add it on as something during that process.
And it would show if you're in court. Look,
Right.
there's another step we
Absolutely.
take. Okay, so employee handbook, good that they have one. Updated 4 years ago, not so good. I mean, there are recent Illinois laws that have come out, and we're going to do some breakfast briefings on just Illinois laws that are new or Illinois laws you may not know about. Your handbooks, federal laws have changed. The Family Medical Leave Act, the Americans with Disabilities Act, there's nuances. So you need to update your handbooks if you haven't done so. Certainly 4 years ago was too long. This idea, we look forward to utilizing your experience and all you learned while you worked at Bitter. That can be misinterpreted, of course, right? And certainly there's no message that we've seen. In fact, this could be viewed as like an opposite message. There's no message we've seen like, look, Shelby, we don't want you to bring or use any of that information, confidential information. And we do want to know what your agreement is, and we want you to comply with that while you work here. And this idea of like, it's nice to say we hope this is a great, long-lasting relationship. You don't want to say anything that basically tries to make it sound like she's going to work here forever, because she probably is what's known as an at-will employee. She doesn't have any agreement for a certain term of her employment, and so she could be, you never know, it may not work out. So those are some pitfalls, and they didn't have her sign anything when she joined, right? If they wanted her to sign an unfair competition agreement, they should have told her that's a condition of her employment, have her sign it then, and make sure they've covered the consideration point.
Okay, so let's read on and see what happens to the riveting story of Shelby Leving as she continues her employment at Happy Corporation. Okay, so for the first 6 months of Shelby's employment with Happy, things went well. Shelby exceeded expectations, recording record sales. Then, in July 2012, Avery received a letter from Bitter, which read, "It has come to our attention that you have recently hired Shelby Leving. Shelby's employment with Happy Corporation is a violation of the confidentiality, non-compete, non-solicitation agreement Shelby signed with Bitter Inc. in August of 2010. Specifically, Shelby agreed that for a period of 2 years, she will not compete with Bitter Inc. directly or indirectly in any business that competes with Bitter Inc. This covenant shall apply throughout the United States, and Shelby also will not directly or indirectly solicit business from or attempt to sell or provide the same similar products to any current or former customers of Bitter Inc. Because of Shelby's unlawful actions mentioned above, Bitter has lost over $1 million. Bitter Inc. will take immediate legal action if Shelby's employment with Happy Corporation continues." Furious, Avery decides to investigate the matter. He asks Shelby about the Bitter agreement. Shelby told Avery that, "I had mentioned that I signed some standard agreement when I was interviewed. No one thought anything of it, and I don't remember what any of the terms were in the agreement I signed with Bitter." Avery told Shelby that he would investigate the matter, but in the meantime, Shelby should continue to perform her job duties as she had in the past. Realizing that Happy might be in trouble, Avery asked Bitter for its entire agreement with Shelby. Once Avery received the entire agreement, he asked Happy's HR director if his wife could review it and provide some free legal advice. She reviewed the agreement and advised Avery that the agreement seemed rather broad and onerous, and that she heard that such agreements are not enforceable. Meanwhile, after Avery and Shelby's conversation, Shelby became concerned about her job security. Shelby thought her time at Happy was limited and began to plot her exit. Shelby spoke to a few coworkers at the office about starting a company to compete with Happy. 2 of Shelby's coworkers, who were disgruntled with Happy's budget cuts and reduced benefits, agreed that they should make a move. Knowing time was of the essence, Shelby and 2 Happy employees began securing office space, informing customers, and taking other steps to hit the ground running after their departure. With such limited time, Shelby and her 2 coworkers did this planning during work hours at Happy's office. Okay, so let's stop there. So what are some key issues here that jump up to anybody? At what steps should have been taken, what may have been done better? Obviously, there's the letter from Bidder. And so what issues does this raise? Well, first of all, it's hard to tell because this is the letter, and Avery does the right thing. He asks for the agreement immediately from Bidder Company. But there's obviously some red flags with respect to whether this agreement by Bidder is even sort of enforceable. It said it was signed in August 2010. As the facts demonstrate, this occurred, the letter was sent in July of 2012. So based on sort of the case law that we've already discussed, in Illinois at least, there may be a 2-year mandatory requirement that individual be employed at their prior employer in order to enforce such an agreement. So these are all, Avery did the right thing. Now he had his, HR director's wife review it, but that's the important step. When you get a letter like this, go through, figure out what you can about the agreement. And the other issue with the agreement, it's throughout the United States. It's not clear, obviously, what type of product we're dealing with, what type of information, but that screams to us as something that would be overly broad and may not be enforceable. So there may not even be an enforceable agreement in this issue, in this case.
Yeah, and what do you think about her activities? Shelby's obviously, she recruited a couple of employees to help with her, and they're starting to take steps to start a competing business during work time. Any problem with that? Okay.
I think even though if she doesn't have an agreement, that still could be disclosed for profit.
Yeah, exactly. I mean, there's like we talked about the outset duty of loyalty. They're also probably using, they're using the company computers perhaps to do this, and hopefully they have a computer use policy, so it's a violation of that policy. And so there's a lot of different ways in which that could be deemed unlawful. And we've had cases like that where, on the one hand, employees can take steps to compete, not during work time, not using work resources. On the other hand, what they do it during work time and what really are steps to compete versus competing. Jordan.
So let's say somebody doesn't have an agreement and they're doing that, they're plotting to go off and start a competing business. What's the remedy besides terminating them?
Yeah, well, so you could terminate, but first of all, it depends on, let's say they've been diverting opportunities. Let's say they have been notifying and soliciting customers on company time while they're still an employee. You could argue that they gain an unfair advantage, and you may be able to get back some of the profits if you could show, again, the ill-gotten gains through unlawful activities. And courts are pretty harsh toward that, because just as they are if someone takes a bunch of documents, one of the first things that happen if you end up in a temporary restraining order scenario like Chris was talking about earlier, they'll say, well, have you taken documents and you better return them? Have you solicited a group of employees? Have you started a competing business on company time, using company resources, or diverting company opportunities? You can't work for one employer and divert opportunities on behalf of another employer. Okay?
And another thing to point out here, Avery did go and talk to Shelby. Obviously, once an executive receives such a letter, obviously the first thing you need to do is go talk to the employee, get as much information about, the previous agreement, the previous relationship that employee has. One thing, though, there's this issue that Avery continued, or instructed her to continue working. Obviously that raises a red flag. Obviously probably the best way is to have her not continue working. especially based on the fact scenario we have here, because obviously, as we've said, as the current employer, you can also be found vicariously liable for Shelby's actions if you believe that she's actually using the information that she gained from the previous employer.
But on that issue,
Yeah. Yep.
in the converse of that, if you say that she's not going to continue to work, and then it's found that the agreement was too broad, was not liable, now she comes turn around.
That's right.
And she sues you and says, because you didn't do due diligence, you didn't really vet this thing properly, and you caused me to lose wages, I think that you may be in jeopardy.
Well, and that is, it's obviously sort of, that's why the investigation is pretty important right up front. If you can weigh, sort of, if you can balance that you feel comfortable, certainly that she's not using any of that information, she's assured you she's destroyed it. There may be, you need to do that economic analysis. And she may be in a position where she's, highly important to the operation of your business. So those are all factors that need to go into it.
Yeah, in a perfect world, you would
Right.
keep her receiving the same pay and have her do something else for a while, if you can live with that. That would be the best thing. So then you're not opening yourself up to what you're concerned about. Yeah, exactly. So let's go through the last. Okay, let's go through the last scenario, last part of the scenario. Avery heard through the grapevine that Shelby was plotting to leave and began a competing business. Avery decided to terminate Shelby's employment. During Shelby's exit interview, Avery told her that Happy was terminating employment because he had learned of her plans to form a competing business. Because Shelby had complained to Happy about a, quote, boys club attitude, close quote, to Happy, Avery's HR director asked Shelby to sign a separation agreement, which included a release of any claims she might have against Happy. Shelby signed the agreement, which also included provisions stating that, quote, this agreement supersedes all previous agreements between Shelby Leving and Happy Corporation. After Shelby's departure from Happy, Avery's executive assistant, Sherlock Holmes, searched Shelby's work computer. Sherlock discovered that Shelby spent most of her final days at Happy planning her departure, including soliciting current customers of Happy. After discovering this information, Sherlock updated Avery. The news infuriated Avery, who decided to send Shelby a letter informing her that her actions prior to her departure were a violation of the confidentiality and non-solicitation agreement Shelby had signed during her employment with Happy. In the letter, Avery also demanded that Shelby disclose all of her unlawful actions during employment with Happy. So here, what do you think of the exit interview, how that was handled, basically? I mean, one of the things is that, he's telling her, okay, he's asking her to sign a separation agreement to release any potential claims because she had complained about boys club attitude. In the process, a lot of those agreements will say just what this said, which is this agreement supersedes any prior understandings and prior agreements. What's the problem with that in this context? The problem with that in this context is that now it supersedes any prior agreements, so it supersedes her confidentiality non-solicitation agreement she had signed. So that's a common flaw. Be really careful about that. If anything, that separation agreement should reaffirm that agreement, okay? And also on the way out, they should tell her, look, you remember, you signed this agreement. So we take this very seriously. We expect you to abide by it. And not only did she violate that agreement, but she also engaged in other unlawful activities. So it's not just, the letter just says, you violated the confidentiality, non-solicitation agreement, but you also engaged in other unlawful activity. And rather than just say, we expect you to disclose your unlawful actions, they should basically say, give us back all the information, all the documents, obtain anything, quarantine her computer. Sherlock Holmes, again, takes matters in his own hands, starts engaging in kind of his own investigation of the computer. We don't recommend that. We recommend you quarantine it, image it if necessary, and ask her to return everything and to stop violating the agreement. And that warn her that not only she, but her new company could be implicated and have to return any ill-gotten gains. And often we'll send a letter not only to the employee who's left, but the new employer to show that they can't engage in any unlawful activity. They could be implicated as well. So now, as promised, pull out the quiz, and hopefully most of these answers will be a lot more readily apparent than they were when you first answered them. So first, number one, unfair competition agreements are governed by federal law. Eric and others have learned that it's really state law now, so that was false.
But it is tricky in your defense because it's based on a national uniform policy. So,
Right.
you know, it is not a fair question.
Right. 2 examples of possible protectable interests include confidential information, long-term customer relationships, and customer goodwill, workforce stability, investment in employee training, all the above. E, all the above, right.
Correct.
Unfair competition agreements can never be enforced because there is a public policy that employees should be free to earn a living the way they want. True or false? False. There is a public policy, but they can be enforceable. Okay. 4, it is advisable to draft unfair competition agreements with the broadest time and scope restrictions possible to deter an employee from engaging in any unfair competition.
False.
False. Remember, as narrowly tailored as possible, and states laws vary significantly. 5, employers should be strategic about indicating which state's law governs an unfair competition agreement, since certain states have more favorable laws for enforcing unfair competition agreements. True. States' laws vary, so if you do business in multiple states, as ROC 10 and others do, be careful and pay attention to which state's law governs.
So for 6, in Illinois, and if an unfair competition agreement is overbroad, courts will automatically find that it is unenforceable. Is that true or false?
False.
False. Remember that Illinois is actually a state that allows blue penciling the agreement, but again, Wisconsin, it depends on the state you're in. Wisconsin is a law where they can throw out the entire agreement.
Yeah, but I disagree with the word automatic.
Right. Right.
Fair enough. I think that's right. Okay, 7. An unfair competition agreement is more likely to be enforced if an employee has worked for a while before being asked to sign the unfair competition agreement, since that is fair rather than imposing an agreement on an employee when an employee first begins employment. What's the first rule about multiple question tests?
Yeah.
If they lead you down a path, go the opposite way. So what's the answer to that? That's actually false. Potentially, it will be, it's got to be based in consideration, less likely to be enforced, and there is consideration problem if the employee has worked for a while rather than being informed at the beginning of their employment. If you tie it to their actual beginning of the employment, you can demonstrate that there was consideration of the actual employment. If they've worked for a while, continuing employment won't be, in certain instances, considered adequate consideration. 8, the Uniform Trade Secrets Act provides remedies for misappropriation and threatened misappropriation of a company's trade secrets by a former employee or a third party with or without a non-disclosure agreement. Is that true or false? It's actually true. So there are remedies available, even if you don't have the agreement in place, that could be available to you as an employer. 9, trade secrets include A, customer information, cost margin and profitability information, formulas and methods for making products, codes for determining discounts, rebates, and other concessions in a price list or catalog. E, all of the above. E, correct.
Okay, number 10, employers must make, quote, reasonable efforts to maintain the secrecy of their trade secrets. Reasonable efforts means all conceivable efforts. True or false? False, right. Reasonable efforts does not mean all conceivable efforts. It means those that are reasonable under the circumstances. 11, reasonable efforts to maintain secrecy of trade secrets do not include A, confidentiality non-disclosure agreements for employees and business partners, B, security precautions, locks, passwords, badges, login screens, etc., C, conducting annual performance evaluations, D, electronic communications, social networking policies, E, employee handbooks. C, right. Courts require employers to take active steps to maintain the secrecy of the trade secrets. 12, an employer may not be liable for the past conduct of an employee, even if that employee has stolen confidential information for the benefit of the current employer. True or false? That's false, right? Chris talked about vicarious liability, where an employer can be liable for the acts done by an employee within the scope of their employment. 13, an employer may limit or avoid liability if it takes appropriate steps to reduce its employees' expectation of privacy in the employer's information technology system. That's true, okay? You want to have that computer use policy that speaks exactly to that you, the employer, can access whatever you need to, and the employee should not have any expectation of privacy. 14, an employee has been given authorization to manage his employer's account information. If the employee emails the customer account information to a competitor, he cannot be liable because his initial access was authorized. True or false? That's false. In fact, there's actually a law related to computer fraud that provides an employee can be held liable for exceeding authorized access. And here, only the initial access of the management of the customer information was authorized.
So 15, an employer can safeguard the theft of confidential and electronic data by making all confidential information and trade secret information accessible on a need-to-know basis. Is that true or false? True, correct. That's, one of the methods we talked about. Shouldn't probably be your only method, but that's certainly one of them. 16, an employer can safeguard the theft of confidential and electronic data by making sure non-compete agreements comply with each state's law, including new rulings or legislation. True or false? True, that's correct, as we've talked about already. 17, having a policy or practice regarding departing employees, such as making sure they return company information or documents, would not help an employer safeguard the theft of confidential or electronic data. Is that true or false? False, correct. When hiring new employees, employers should be straightforward regarding expectations and policies. It is impossible to be too blunt. True, that's correct. 19, when a company hires an employee, it should ask the employee to bring information about customers from the employer's former employee so that the employee can hit the ground running with the employee begins employment. I hope nobody answers true on this one.
Never hurts to ask.
Exactly. And then 20, when an employee resigns, if the employer suspects improper activity on the employee's part, the employer should immediately start searching the computer that the employee used during the employee's employment to seek to uncover any wrongdoing. Is that true or false? False. That, you should quarantine it, but don't do your own investigation.
Okay, so
Great.
you all have been tremendous with your questions and participation. Any other questions at this point? Anything? Jordan?
One more question.
Sure.
So with respect to non-solicitation in particular, what about LinkedIn? And, somebody is all connected to all their customers, and then, they don't take any information with them, they don't contact them, but then they update their information on LinkedIn, automatically it goes out, lets everybody know kind of where they're at.
On LinkedIn, right?
Yeah.
Okay. So technically, it depends on how the non-solicitation agreement's drafted, but technically, it usually would be will not solicit, induce or whatever. So technically, that's not solicitation. You're just letting people know where you go. And this is where legal advice is really important. Like, what can that employee do? Can the employee notify to say, I just want to let you know that I made a job change and now I'm at whatever. That's really not solicitation. Usually, the agreements are drafted pretty broadly, like will not directly or indirectly solicit, whatever. But technically, it's not solicitation, and it depends on the specific language of the agreement too.
I got a question.
Yeah, sure.
Have you ever seen a case where the employee alleges that they were discriminated against because not every employee, even though maybe in the same level, had to sign this agreement? And they held that as a reason to say the agreement should not be enforced, even though they had signed it. But they found out that maybe the boss's nephew has the same authority, but they didn't have to sign the agreement.
That's a great question. No, we're going to make that our next scenario, I think, because we deal with a lot. With the discrimination analysis, one of the key questions you ask is, well, how have other similarly situated employees been treated? And I have not seen it come up in the context. That's a fascinating question.
Right, or for instance, like maybe a female employee had to sign it, but the male employee didn't have to sign it.
Yeah, exactly.
And I mean, I think that'll go back to the original analysis of, are you really going through the proper steps to keep something, non-confidential, or, and you're going to need to demonstrate. And if it's a discriminatory reason or something, probably a court isn't going to look too favorably on your internal processes to keep these things safeguarded.
Yeah, that's a really interesting question. Any other questions? Jeff?
Years ago when I was in R&D, my non-compete was written in such a way that I wasn't allowed to go to a competitor. If I did, at my former employer's discretion, they had the option of paying my new salary for the period of the agreement, and I would not work. Have you seen those before?
Yeah, definitely. So a lot of times we'll represent hedge funds, for example, and they'll have, some of them will have agreements where just that, like you'll pay someone to sit on the sidelines, which really, if someone's willing to do that, that really makes it even more capable of being enforced, because again, the employee who's left, they're giving up certain rights, their activities are restricted, but they're being paid to sit on the sidelines. Judges will say, well, that's really fair. Some of those, sometimes you'll see an agreement will say there'll be like an election period. There'll be this agreement may be enforceable for 0, 3, 6, or 9 or months or 12 months, and we'll decide within 10 days after the employee leaves employment. We've seen those, and the key is the employer's got to remember to actually make that election going back. But yeah, and there's also something called the inevitable disclosure doctrine, which is like if someone has a formula for Coke in their head and they go work for Pepsi, it's deemed to be, and this is very rare circumstance where someone's got something like that. Depending upon their position, it may be deemed that it's impossible for them to work at Pepsi in R&D, let's say, and then not disclose that formula for Coke that's confidential. That's another way where someone would be, possibly could be restricted from going to work elsewhere.
That's the way mine will provide my new form.
Yeah, okay, so something like that. But yeah, I mean, if an employer can live with paying someone during the period of their non-compete, let's say if it's a literal non-compete, that's the best thing. And going back to the initial idea, I mean, you can have, and we have had it enforced, where someone's literally not able to work for a competitor for a certain period of time, depending upon the facts and circumstances, the applicable law, and again, the judge. Okay. Any other questions? I just want to give you a reminder, if you'd like to be on our list for client alerts and other breakfast briefings and seminars on a variety of topics, please just give us your business card. But again, thanks, you've all been tremendous, and thanks for sharing, Bruce and others, sharing your own experiences. I think it's helped a lot. Okay?
Yeah, thank you very much.
I'll be here for other
everybody. Nice
questions.
to meet you all.
Yeah.